Hello, welcome to another edition of At Home with the Roosevelts. I'm Paul Sparrow, the director of the Franklin Roosevelt Presidential Library Museum in Hyde Park, New York. And we're recording this session on September 17th, which is Constitution Day. What better way to celebrate Constitution Day than to talk about the Supreme Court with two outstanding experts on the subject. No president had a more significant impact on the Supreme Court than FDR. He appointed 8 justices during his administration, some of whom helped change American democracy for the better. He got to appoint no Supreme Court justices during his first term, which was a point of extreme frustration for him, and we'll get around to talking to that later. Now, the role of the Supreme Court has changed over the years, and certainly today's play a central role in our political process. But make no mistakes, the court has always been political. Joining me today is John Q. Barrett, professor of law at St. John's University and the Elizabeth Lena Fellow at the Robert H. Jackson Center. He's the biographer of Justice Jackson and writer of the Jackson List, a popular email newsletter and website, and discoverer and editor of Jackson's acclaimed 2003 posthumous book, quote, That Man, an Insider's Portrait of Franklin D. Roosevelt, the last New Deal insider memoir. Also with us today, Ralph Blumenthal, distinguished lecturer at Baruch College in New York, a former New York Times reporter, and it continues to be a periodic contributor to the Times and other publications. He's the author of 5 books, including The Believer, about the Harvard psychiatrist John Mack, who investigated UFOs and alien encounters, but he actually has a very direct connection to FDR and his administration. We'll talk about that in a minute. We'll start with Professor Barrett. Give us a little bit of your background in regards to the Supreme Court and specifically your work on Justice Robert Jackson.
Sure. Well, thank you, Paul, for this opportunity and really the privilege to be at the Roosevelt Library and Homestead in every sense except actual. The path that led me to all of this was really being a lawyer in Washington at first. I worked in the Department of Justice in different federal investigations for about 7 years, and then became a law professor. Among my areas, public life, public figures, legal ethics, and constitutional law, and sort of a converging on the Supreme Court and the people on the court, and Robert Jackson in particular, someone who was in Roosevelt's cabinet as Attorney General, was confirmed by the Senate through Roosevelt appointments to 5 separate jobs in a very short run of years. Became my big project. And for our topic, it matters that Jackson was an assistant attorney general in 1937, a principal witness defending the president's courtpacking plan, and then the solicitor general who over the next 2 years argued in defense of New Deal laws, constitutionality before the Supreme Court. So it's the Jackson path that brought me into this Roosevelt world and courtpacking, court reform as a topic.
Jackson was also, of course, part of the Nuremberg trials, which we can talk about separately. But so, Professor Blumenthal, give us a little bit about your background, both as a reporter and as the archivist of the Baruch Library's collection, one of the key members of FDR's administration.
Thank you, Paul. I really appreciate being on with you and John. I am a distinguished lecturer at Baruch College, as you mentioned, and in that capacity supervise our archives collection in the Newman Library, among which we have a collection of the papers of Luther Halsey Gulick III, who was a member of the Brownlow Committee that really reorganized the executive branch for FDR. And that came up actually right in the middle of the courtpacking fight. So that's interesting. I also was on the New York Times for 45 years, and one of my happiest stories actually was being up at the Roosevelt Home and Library to do a story on Top Cottage in 2001 when it was renovated. Also, I've written at the Times a lot about the Holocaust, and of course, Robert Jackson's role as prosecutor at Nuremberg is a very sterling episode in the prosecution of the Nazi criminals. So anyway, and I should say that I came into this subject through a book called The 168 Days, which is a virtual diary of the court packing controversy, co-written by Turner Catledge, who was managing editor of the New York Times when I started there in 1964. It's a book co-written with Joseph Alsop, and it's a wonderful account, not completely unbiased, as we can discuss, of the day-to-day struggles back and forth, over the Courtpacking controversy. So it's a privilege to be here.
Well, I'm glad to have you here. And for those of you who don't know, Cottage is a home that FDR built in Hyde Park here during the late 1930s that he planned to move into and live in after he left the presidency. And it's especially designed, it's really one of the first houses in America that was designed to accommodate a handicapped person with a wheelchair. So there's no thresholds on the doors, all the windows are low, all the handles to the doors have certain kinds of levers. It really was a architectural marvel. It's only open part of the time, but it's part of the National Park Service's collection of properties up here. They have the Roosevelt Home and Eleanor's Home at Valkill and Top Cottage and the Vanderbilt Mansion. So quick plug, if anybody's coming up to Hudson Valley, make sure you stop here and visit in. All right, back to the subject of matter. So let's talk about FDR's Courtpacking scheme. So John, we'll set the scene. What were the circumstances that made FDR so frustrated with the court? And then when he's done, Ralph, talk about what did he try to do to change it?
Well, I think you have to go back a little bit before his presidency and remember that we're in the Great Depression. The stock market crashed in the fall of 1929. And coincidentally, during that term, President Herbert Hoover had 3 Supreme Court appointment opportunities. And he made great appointments, no denying that. And it's the luck of the draw whether a president gets vacancies, and the chance President Trump got 3, President Hoover had 3. Franklin Roosevelt, elected in 1932, inaugurated in 33, during that first 4-year term got 0, as you mentioned, Paul. He had a supermajority in both the House and the Senate, and there was an attack of legislation on the problems of the Depression. The torpid voluntarism of the Hoover era was replaced by the New Deal. And the New Deal ran into a Supreme Court roadblock. In the course of that 4-year term, not only did Roosevelt have no chance to appoint justices, but the 9 who were there struck down major reform relief laws. This is a quick laundry list. The National Industrial Recovery Act, the Railroad Retirement Act, Section 3 of the National Recovery Act, the Fraser-Lemke Act, the tax component of the Agricultural Adjustment Act, the Bituminous Coal Conservation Act, the amendments to the bankruptcy law, and a state New York minimum wage law that was a kind of state level counterpart progressive effort. So Roosevelt was the popular, powerful, and democratically responsive president, and the Supreme Court was a tremendous obstacle. And so reelected overwhelmingly in 1936, he decided to use his political capital on his Supreme Court problem.
Now, Ralph, what did he do? What was his strategy? What was he trying to accomplish here?
Well, he took it very personally. Actually, he had this dream of that the Supreme Court would cooperate with him in getting his programs through, his New Deal programs. Now, maybe John can help me understand and our listeners whether Roosevelt was being disingenuous or whether he really believed that the separation of powers didn't apply to him. Because the idea that, he would, as he came up with the idea, appoint 6 new justices and that he would cooperate with them, or they would cooperate with him in getting his program through is, insane to our way of thinking today. So it's a mystery to me, how much he believed, that he could really merge these 2 branches of government. But what happened is he was really smarting under these rejections, although the court overturning of the NRA actually probably helped him in retrospect because it was so unpopular. But anyway, but he was resolved, and this is really unlike him with his perfect temperament and his great sense of timing and, his wonderful way of reading the country. He kind of lost it. And he decided to put all his chips on this plan to change the court. And there were 4 actual proposals given to him by Homer Cummings, his Attorney General. One was a constitutional amendment, which would be very difficult. One was statutory to change the jurisdiction of the court. And there were, various ways of tinkering. And the last one was to add a provision that whenever a justice reached 70, he or she, those days, she, would have to step down, or Roosevelt could appoint somebody to take his place. So that was his plan, and he somehow got convinced that this was doable. And as John said, I mean, he had this wonderful supermajority. He had coasted in with the 27,000 votes, a huge majority in 1936. So he had every reason to think that the country was just waiting. Labor was on his side, liberals were on his side, that this would be welcomed. And of course, it was not.
So a little context here. So the 1936 presidential election, as you mentioned, was the largest electoral landslide in American political history. And I always think that FDR had just an extraordinary political instinct that had gotten him to where he was. The fact that he was elected and then reelected in a wheelchair is simply incredible on every level during one of the darkest times in American history. But I also like to point out that he made the three biggest mistakes of his entire political career, I think, during that period after the landslide victory. He decided he was going to try to pack the court. He decided he was going to, primary the conservative Southern Democrats who are holding up his legislation in Congress, and he cut the budget, leading to the Roosevelt recession of 1937. So he sort of, as you said, he lost it. I think he was so enthralled with his own success and popularity that he tried to do things that were way off the path of what the American public wanted. Now, John, talk a little bit about what the reaction was when he put this forward. Even his own party had trouble supporting him in this court packing scheme.
Yeah, the Constitution does not prescribe a size for the Supreme Court. It's a creature of statute. Right. And originally the court was 6. It went down to 5. It oscillated around in the 19th century. But since the 1870s, we've had a 9-member court. And so it's now about 60 years of the country being used to 9, as if it's etched in marble. And I think that's a visceral source of the reaction, that trying to somehow in one fell swoop potentially grow the court to 15, and of course fill it with like-minded New Dealers, was somehow un-American, even though it's not unconstitutional. And it opened up some of the fault lines in the Democratic Party. There were old barons who were the committee chairmen, and there were Southern segregationists who were a part of this coalition that Roosevelt was trying to hold together. And the court as a target was not such a publicly notoriously evil institution, especially the way Roosevelt spun it out. He claimed in the announcement that the justices were so far behind on their work. There was a pile of unaddressed certiorari petitions, which is, of course, jargon and wasn't true. He also claimed that these aged justices, no longer had their fastball. And that was a hard thing to claim about, Louis Brandeis, oldest of the bunch. And so that sort of spin hit a wall of hostility, and it immediately became controversial. Now, Roosevelt did try to recalibrate, and Robert Jackson was one of the people who told him, you need to start telling the truth about this. It's not about age. It's not about backlog. It's about interpretations that particularly the 4 most conservative justices have poured into the Constitution. They've read Congress's power to regulate interstate commerce, too narrowly. And they've read states' powers to protect social welfare and use their police powers much too restrictively. This is about the court putting itself and its political preferences in the place of the proper understanding of the Constitution. And so democracy can and should respond by appointing more straight shooters. I would even say more conservative justices in terms of constitutional interpretation than these 4 horsemen radicals who were Roosevelt's problems.
But you know what I found interesting, if I could just jump in here,
Yeah,
it wasn't dead in the water from the beginning. It might have seemed that it would be because, Vice President Garner came out of the meeting where the news was sprung on him, holding his nose and going like this. But I think he had a good shot at getting this through because of all the reasons we mentioned, his popularity, his, election landslide, et cetera. But through a series of almost biblical or Greek, whatever you want to call it, missteps, he just succeeded in sabotaging himself, Roosevelt. So even though it was not a popular thing to change the third branch of government, it could have been done, it seems to me, if it had been handled differently.
And it's not just self-sabotage. There are external events. I mean, there are a couple of things that sort of happen in that first 30, 40 days. Announcement of the plan in February. By early March, the Senate hearings are starting. The Supreme Court justices send a letter to the chairman of the committee that basically says we're current on our work. So they blow up the cover story. But then the Supreme Court in mid-March starts to hand down decisions upholding New Deal laws. So all of a sudden, this Supreme Court problem is receding. A state minimum wage is upheld. The National Labor Relations Act is upheld. Social Security is argued that spring by Robert Jackson and Charles Wiesanski, and in May, its constitutionality is upheld. So that kind of confluence of events, I think, really made it much less necessary to do something dramatic.
And of course, that change in some of their decisions led to one of the great catchphrases of the Supreme Court history, which is the switch in time saves 9, right? You want to explain that, Ralph?
Well, Roosevelt, as I made a note in my notes here, he wouldn't take yes for an answer. The court went out of its way to, I don't know whether they designed their decisions in order to placate him. I mean, that's a good question. Was this done with design, or whether they saw the light and realized that they had to uphold these good New Deal programs? For whatever reason, the court started to give him what he wanted, and they basically, I don't know, you want to use this image, but he dug his grave for him, and he jumped in, but he didn't have to. And he just, it really is amazing how he missed all these signals and just plowed ahead. He was determined to remake that court, to put on the 6 justices, or up to 6, who would carry through his programs. But it's just astounding. I think there's this sort of still a political mystery because the Turner College book that I reference, he and Alsop interviewed everybody but the president on this. So we don't know. I mean, I don't know how much maybe John knows, in Roosevelt's own writing and what has come out in his papers about what his thinking was about this, why he wouldn't take yes for an answer.
Oh, he was much too careful to leave a paper trail on anything.
Well, we have a question from the audience, from Carmelo Calcano. I hope I pronounced that right. She asks, how do we know Courtpacking was unpopular outside of the conservative voice in the court and Dem Party? Did average Americans in 1930s Depression have a strong opinion on the court?
Well, the farm and 2 strong constituencies of Roosevelt, the farmers and labor and the liberals, all turned against it pretty quickly. So he lost his natural constituency. So it was not popular from the beginning. It's interesting. He thought, obviously, Roosevelt thought that it might be, which is why he embarked on it. But he started losing his natural allies from the beginning. Am I right on that, John?
No, I think that's correct. And, look at the mailbags, some of which is archived there.
We have millions of letters.
Right. I mean, you can measure, page by page, the public reaction, and a lot of it is very critical. And you can look at the congressional committee votes, and ultimately the congressional committee report, the Senate committee report, rejects the first version of the proposed bill. But as the urgency is receding in the springtime, the president does pull back. And there's a second version that would have only expanded the court by 2 seats that, I think he well would have won if that had been pushed through to a vote. He kind of had a deal with the Senate Majority Leader, Senator Joseph Robinson from Arkansas, who was going to get that over the finish line. And Roosevelt had frankly promised him a Supreme Court appointment, one of the 2 seats. And Roosevelt was making nice a Jefferson Island picnic with every member of Congress early that summer. And Robinson dropped dead right after the 4th of July. And at that point, he already, one more development, Justice Van Devanter had announced that he was resigning. So Roosevelt finally had a vacancy to fill. So at that point, just none of it is worth any more trouble. We can live with 9, and you see the dominoes. Hugo Black is appointed in August, Stanley Reed the next year, both Felix Frankfurter and William O. Douglas the next year, Frank Murphy the next year, Robert Jackson and James Burns the next year. I mean, those 8 Roosevelt appointees are just, one after another in the wings, starting in the summer of 37.
Well, I mean, there were so many opportunities for him to compromise, and they came to him. Homer Cummings, not so much Cummings, who was a true believer as his attorney general, but others came to him repeatedly with offers. Wheeler, for example, Montana, with offers to compromise, and he just wouldn't have it. I mean, he was dead set on moving ahead, and he wouldn't even recognize the reality of what was happening. His own allies were coming to him with stories of what was going on out there, and how he was losing, support and constituencies. But he was very bullheaded in that, and it is extraordinary. Again, with the sense of timing we credit him with, and his exquisite sensitivity to political winds, he just was dead set on this.
There's a little kernel in this that I think is maybe an explanation of that. Homer Cummings, the Attorney General, was really the draftsman and the proponent of this. And part of the problem on the Supreme Court was Justice James McReynolds. He was one of the 4 horsemen. He was a Wilson appointee. He'd been in the Wilson administration with FDR. And as Attorney General, McReynolds had drafted, in effect, a court-packing plan. When Cummings found that and told it to Roosevelt, they both thought it was just such an incredibly wonderful, karmic thing to take out McReynolds with a McReynolds proposal, if you will, that I think they got too attached to the idea. And that kind of held their enthusiasm in February and March and into the springtime before finally recalibration starts.
So we have another question here from Maris Connell Sparrow, my wife. She wants to know what determines how many justices can be on the court. So does Congress have the power to change that number? And can they change it down? Can they as you said earlier, it's been 5, it's been 7. Basically, is that a Senate?
It is entirely a statutory matter. It's a next Judiciary Act, if you will. It could create a Supreme Court seat, or if one became vacant, it could abolish one. I don't think a law could abolish a sitting justice.
Right.
The Constitution protects against that. And also, in older history and in recent history, we've seen that the Senate has the power to sit on a nomination. And so by attrition to shrink the court. That happened under President Andrew Johnson. And of course, it happened under President Obama for a stretch in 2016.
And also, Congress has the power to limit the jurisdiction of the court. I mean, they could say that the court would need a supermajority to overrule any decisions, or they could tinker with the mandate of the court in so many different ways, which is interesting. We think somehow that's protected in the Constitution, but it's not. So Congress could have not only changed the number of justices, but reorganized their responsibilities.
Okay, so I'm going to go back to something that John was talking about, which was this string starting in the second term of the administration going forward with this appointment of 8 justices. I'm going to ask you both a difficult question. It's like, who's your favorite child? Of those 8, who do you think was the most significant appointment that he made in terms of both changing the court and changing America? John, I'm going to point to you first.
Well, I've got a bias, but it's, I think, well-founded in favor of Robert Jackson, who I think was an incredible talent, a beautiful pen, probably the best writer in the court's history, and a case-by-case jurist. He didn't pigeonhole easily. It turned out to be quite a fractious court, this Roosevelt court that began in the late 30s and lived on through the 1950s. And Jackson was kind of more on the conservative side, but in the middle, if you will, and much more a case-at-a-time person. So he's a dissenter in the Japanese-American exclusion case, Korematsu, for instance. I think as talent, Jackson is the person. In terms of significance, I really think maybe Hugo Black, because he broke the ice.
Right.
You know, that really started the flow. And of course, Black served until 1971, a long and distinguished career, perhaps to overcome the stigma of having been a Ku Klux Klan member, and that coming out just after he's appointed to the court, undeniably. He charted an egalitarian path through our constitutional law. And by the late 1940s, really was becoming the leading civil liberties justice, and was that for most of the rest of his career. So I think he's also very important. But I have two children. I don't pick favorite children. I look at these justices and think really it is an all-star team. It is quite a talented roster, with almost no exception.
Okay, Ralph, who do you put your money on, Ralph?
Well, I would say Black also. It is interesting that Roosevelt claimed later, and in fact, it's probably true, he was blindsided. He didn't really do his homework on Black and his Klan membership, although it ended up pretty irrelevant based on the direction he took on the court. You know, it was also interesting that there was this deal to appoint Joe Robinson to the vacancy after Devanta retired. And Robinson, of course, was carrying the president's water all through the Courtpacking case. He was the Senate Majority Leader who literally worked himself to death and died before he could be appointed to the court. But Roosevelt had turned on him, and he was afraid that as a Southerner, he wouldn't carry through his liberal agenda. So he left Robinson hanging, and it was really a very sad episode in history. And Robinson, I found out his best friend was Bernard Baruch. I didn't know that. But
there's a college named after him, isn't there?
Well, that's where I work, Baruch College. And Baruch, of course, being a famous financial advisor to FDR. But it is strange that just the way things turned, that the whole thing could have been settled long before it went down to defeat. If the plan had been carried through, Roosevelt was going to appoint Robinson, compromise, maybe appoint 2 justices, not go for the full 6. But as I keep coming back to this, he was adamant that he was going to have it his way or the highway.
Paul, I have 2 more quick comments about the appointees. I want to flag Felix Frankfurter because he was, of course, brilliant.
One of my personal favorites.
And sort of in his career stood, I think, most closely to the judicial restraint model that actually the Courtpacking proposal is about, that our policy in our country should, by and large, be made by our elected representatives, and it's the Supreme Court's job to get out of the way of a government that the national government and also state governments have ample powers in our system. And so Frankfurter is a kind of through line, and also just a charming and fascinating character. The other person that I think we all forget is that Roosevelt elevated Harlan Fiske Stone to be Chief Justice. Right. And Stone was already an Associate Justice. He was a Republican. He was a Coolidge appointee to the court in the 1920s. And Roosevelt did that in the summer of 1941 as a sort of bipartisan, non-political move. And that's a lost art. But that was a great thing that the president did.
He was a member of the liberal minority, though, wasn't he?
He was not one of the 4 horsemen, to be fair.
Right.
Yes.
And interesting, Frankfurter actually opposed the Courtpacking plan, right? I mean, he was
in his private heart. He held his powder and did not do anything publicly.
Roosevelt became very frustrated with Frankfurter. So we're going to go back in time for a minute, and then we're going to come up to present day. So I want to go back to talk about why the Supreme Court has this power to determine what's a constitutional law and what's not. And it really goes back to the very founding days, the early 1800s, with a rather extraordinary legal case of Marbury versus Madison. And we'll start with you, Ralph. Talk a little bit about this and why this laid this foundation that basically said, well, the Supreme Court gets the final say.
Was that to me?
Yes. Sorry.
Oh, Well, Marbury versus Madison established the right of the Supreme Court to rule on all legal matters in the government, and it's not in the Constitution. They took on that power, and later on it was deemed worthwhile in terms of balance of powers. Without that, the court would have been really a weak sister to the other two branches. So it's an interesting example of how the founding fathers hadn't thought of that, but once the court came up with it, everybody said this is a good idea. The court should have that power. So and it became ingrained in our system. And today we can't think of what it would be like without it. So it really is a great example of how the Constitution actually is a living document. I mean, it just added this element that it never had in the beginning, and everybody said that's a good idea.
Right. Well, there is in Marbury a sort of logic that gets them to the assertion of the power to engage in judicial review. That the court has to decide cases. It decides cases that arise under the Constitution. Sometimes a provision of the Constitution might be in conflict with a statute. Deciding the case means deciding which of those carries the day. And so the answer is that the Constitution defeats a statute, that the court strikes down an unconstitutional statute in the context of a case. That power of judicial review, though, is different than that answer becoming the authoritative last word. Right. In other words, judicial review becoming judicial supremacy. And I think that process is something that we all sort of wrestle with because what the Courtpacking plan was pushing back on was judicial supremacy being asserted over New Deal laws in the early 1930s. Robert Jackson wrote a whole book about this called The Struggle for Judicial Supremacy, published just as he became Attorney General in 1940, which is about historically the Supreme Court as an institution inflates itself as big as it can get away with, as we will let it get away with. And Marbury was the start, and we have kind of admired the craft and maybe let that grow too big. And at other times we've pushed back. 1937 and Courtpacking is one. Judicial self-restraint by individual justices is another. And proposals for court reform today, obviously would be in that vein.
So we've got some good questions coming in here now. And please, if you have a question, just put it in the chat. From Joanne Moritz, she wants to know what argument was given for increasing the court from 6 to 9 in the first place, and when and who did this, and did they face similar opposition? That's a great question.
Yeah, it wasn't in one fell swoop, but generally it relates to the structure of the creation of the lower federal courts. So as the number of circuit courts grew, a corresponding Supreme Court justice, because of the circuit riding responsibilities, largely explains the early growth in the oscillation. Because those circuit panels were a justice visiting and riding and joining in the circuit court activity. And then I think it's workload driven. As there's more and more cases coming within the jurisdiction of the court, I'm sure the Supreme Court was communicating to the Congress, we could use another guy up here. And so laws grow the size of the court. And, that's largely what got us to 9.
So it was less political and more workload.
I think structural for the judiciary and workload.
Right.
The political moment is more in the post-Civil War non-filling of vacancies, when the legal tender case was pending before the Supreme Court, and basically the Congress let the court shrink rather than let Andrew Johnson grow the court in the wrong direction that would have threatened Reconstruction.
Right.
Interestingly, one of the original proposals for reforming the court, along with the packing, was to designate different districts for each of the justices, right? That they would come from 9 different parts of the country and all that. And that actually limited Roosevelt at one point when he was trying to think of 2 people. Wasn't Robinson from one of the places, Arkansas, or somebody came from the same place as another justice, so he had to be ruled out. But that was one of the ideas, to try to get the justices picked from different parts of the country.
So we have a question from Princess Michelle, Your Highness. Do you have any information about how President FDR celebrated the American holiday Thanksgiving? My mom and dad were born here during his term of service in the USA. My mom during the American holiday Thanksgiving the same year. So I can answer a little bit of this, which was that for many years, FDR would celebrate Thanksgiving in Warm Springs, Georgia, at the rehabilitation center for polio that he created down there. He bought this old rundown spa and turned it into the world's premier polio research and rehabilitation center. And he would go down there every Thanksgiving and spend time with the patients. Now, he first bought it in the mid-1920s, so he went there for quite a while before he became president. But even as president, he would go down there. He could drop his act, and he could let people know that he was crippled and handicapped, and he would swim in the pool with them, and they called him Doc Roosevelt. And it was a tradition that really meant a great deal to him. Good question.
That image from photographs is the first thing that came to mind when I heard the question. The other thing that I know, but not in detail, is that the date of Thanksgiving, that particular Thursday, was standardized under Roosevelt. So it made it more of a national holiday and a fixed date.
Well, it was standardized because he created a controversy. The retail industry asked him to move it up earlier so they had a longer period between Thanksgiving and Christmas for people to buy things. So he moved it, and there was such an outcry about it that he had to move it back and solidify that date forever.
Paul, you mentioned his polio. We should not let.
Nope, we lost Ralph for a second. Technical wizardry. Ralph, we've lost you. So
are we back?
See you come back. Are you back?
Yeah.
Okay. Go ahead.
How's that? Is that all right? This is the 100th anniversary of FDR's polio in 1921. And that, of course, made him, the great leader he was. It gave him the empathy. It gave him the strength, the power to overcome, adversity, skills that kind of, he abandoned, or that abandoned him during the Courtpacking thing. I mean, the empathy, his wisdom, he was left with a strength, which of course he had in excess, maybe too much in this case. But it is interesting that this is that important anniversary. How history would have been different. He may never have developed into the leader he was if he hadn't had that adversity to battle against.
I absolutely believe that. We have a great question which has come in from Christopher Padigo. He says, was James F. Burns' appointment Roosevelt's way to pay him back for not taking him on as vice president? A little political history here as well as court history. Certainly an interesting character, Burns. He was threatening to run against Roosevelt as well. Any comments on that?
Yeah, I'm not sure how explicit that was. I mean, it's 1941, so it's after 1940 has occurred and it's over and done. And I'm not sure what Senator Burns would have done to a third-term president. And they obviously had a fine relationship, and Roosevelt had a high regard for his talent, not only because he put him on the court, but a year later, when Burns frankly hated the job anyway, Roosevelt pulled him off the court and brought him into the White House to basically manage the economy during the war. I think temperamentally, Burns was just an executive branch manager or a legislator way ahead of being a judge.
Right. You agree with that, Ralph?
I'll defer to John here, much more of an expert than I am. But it is interesting, the people who ended up being with the president on this Courtpacking thing and the ones who were against him. I mean, it was a very, very select group that gathered around him, and a loyal group, Tommy Corcoran and others, who really stood with him at a time when so many other people, were abandoning him. Wheeler and Connolly and others. And Garner, of course. So it is interesting that he had this, small circle of people who were absolutely, and Jackson. I mean, Jackson was one of the people who really stood by the president, right, John? I mean,
yeah, no, that's right. Jackson in That Man, his memoir that was never published in his lifetime, but I had the luck to find the manuscript and the family support in publishing it. He, in about 4 pages, tells his experience with Courtpacking, and he recounts going over to the president, to the White House, for a meeting of that inner team in February when this has been announced and it's off to a bumpy start. And Jackson's telling the president, before you go fishing, before you head out of Washington, you really need to sort of have another crack at explaining this, because a pile of unaddressed certiorari's is really not carrying the day. And Roosevelt, according to Jackson, kind of paused and said, yeah, that really is a pretty terrible explanation, isn't it? And then he went into a fireside chat and started to tell the truth. And, it was much more of a political process that had a chance thereafter.
Right. All right, we've got a lot of questions coming in, but I want to jump up. There's a question here from Camilla again about the connection between justices and political perspectives. And the question is, did the 1930s justices have similar controversies, or is this more of a modern development in terms of overt political connections outside of the court system? We'll start with you, Ralph, on that one.
Well, I would say that the Turner Catlett Joe Alsop book, 168 Days, really opened my eyes to the poisonous atmosphere in Washington then. I had this sort of halcyon vision of the New Deal as a program that everybody subscribed to. It sailed through. Roosevelt saved the country. And you look back, and we think our time is, full of internecine strife and, political poison. My God, what went on then, the back and forth? It's amazing. Now, the court, I don't know how much the court itself took part in that, because we don't know. And the book itself says we don't really know what went on behind closed doors at the court. We still don't. But certainly all around the court, the atmosphere in Washington in those days was murderous. And so, in that sense, nothing has changed.
Right. But if I'm understanding the question, if she's asking about Supreme Court appointments and were there poisonous fights in that context, generally no. The one that, Roosevelt had a big majority in the Senate and he could get his appointees confirmed. That's a fundamental difference from his time to our time. The one who had not hard sailing, if you will, but an ugly, ugly whispering campaign around it from the bad side was the nomination of Frankfurter in January of 1939 and the anti-Semitic reaction to that. And frankly, that whole nomination was Roosevelt not giving a damn about anti-Semitism, and in fact, maybe sort of flicking his chin a bit at Adolf Hitler by putting America's leading lawyer and prominent American Jew on the Supreme Court.
Yeah. Also, the senatorial courtesy in those days was really strong. So if and when Roosevelt nominated a senator like Hugo Black, that immediately sailed through because of senatorial courtesy, which I don't know if we'd still have that today.
Right. It seems highly unlikely, but there is a sense, I think, that many people have today, particularly people who aren't history buffs like we are, that this contentious nature of the Supreme Court is new. This is a new phenomenon, and that it used to be they would just sit in their black robes in the Supreme Court and hand down things and everything was fine. And I always like to point out, have you heard of Brown versus Board of Education? Which I think is an interesting thing to look at here because of the connection it has back to the Roosevelt court. And there was perhaps no decision in American history that has had more, maybe Roe v. Wade, more significant consequences on the way millions of Americans live. Talk a little bit about Brown v. Board and how that came about and why it was such a revolutionary decision, because it really did take them out of their traditional role. We'll start with you, John. Sorry, big grenade for you here.
That's such a huge question. The starting point is obviously the creation of this country as a slave country, with our Constitution ducking that fundamental moral question as the price of ratifying a unity of slave states and free states. And race through the 19th century and the Civil War and the amendments after the war is our fundamental historical reality, our permanent challenge, our deepest sin. And we won World War II with a segregated army, fighting against, racial supremacy theory opponents. That all came home and had to get sorted out. The dissonance of, Nazism and Imperial Japan and coming home and being a racially segregated country is what the NAACP attacks. And it's what a court filled with Roosevelt appointees still, Frankfurter, Jackson, Black, Douglas are the heart of that court. begins to deal with in the late 1940s. And, they're the leading edge. For them, this is not at all a hard question morally or personally. In various ways, it's a challenging legal question because the guys who wrote the 14th Amendment were segregationists. And frankly, Jimmy Burns, who we were talking about earlier, by this point is governor of South Carolina, and he's a segregationist. And a lot of the country is still, ugly in racial terms and segregationist. The Supreme Court, with Earl Warren's leadership and with the Truman appointees completing the roster, in a series of decisions, worked its way to giving meaning to the Equal Protection Clause. And I think it is our finest moment in constitutional history.
And you couldn't draw a clear division between the Congress and the court at that time. The Congress was controlled by Southerners with the seniority system, and all segregationist, powerful committee chairmen, people who Roosevelt, of course, had dealt with all through his administrations. And yet here we have a Supreme Court that's taking a radically, different approach to equality and the new shape of American society. So if it had been up to Congress, we never would have desegregated the schools.
Yeah, and I find it an interesting bookend to the Korematsu case and the other Japanese incarceration cases that came up during the Roosevelt administration, where this idea of the protections of American citizenship was essentially thrown out the window. And I have to wonder what those conversations were like. As you pointed out, Jackson, of course, a dissenting voice, as Eleanor Roosevelt was in a non-judicial sense. But that Korematsu case really, I think, stressed the court in a way that forced it to make a decision, because you're in the midst of this war and you have this sort of, fear gripping the country. How did that decision come down, and why did they not acknowledge the constitutional rights of American citizens who happen to have Japanese ancestry?
Well, they did and they didn't. The court decides the series of Japanese American cases in a kind of slow walk. So the curfew case doesn't get decided until 43, and the exclusion and internment cases don't get decided until late 44, by which point the war in the Pacific is far, far, far offshore and approaching Japan, through the island hopping carnage that we were winning. And so the imperative of national security is gone by that time. The majority fictionalizes that we're still at the time when the president and the army decided that we had a security concern, and the court majority defers to that. National security is, of course, a real thing and a vital thing, but it's also something that can be used as a cudgel. And the Supreme Court, was beaten down by the claim of national security.
And, you only have to look at the climate in this country after 9/11 to see how inflamed, the society can be by Pearl Harbor attack then and the 9/11 attacks then, now more recently, all the statutes that were passed about militarizing the police and invading, privacy and monitoring the Muslim community, and all of the Patriot Act. So we don't have to look back that far to understand the mentality of the country after Pearl Harbor. Just look at what happened after 9/11.
Yep. No, I think it's interesting that the Supreme Court, again, played a key role there in determining whether these Muslim bans, travel bans and things were constitutional. And, again, it found itself in the middle of this political firestorm, as it has with so many cases. So when President Biden was elected, and after the 3 Supreme Court justices being appointed by Trump, there was this movement that he should pack the court, and sort of walk us through. We'll start with you, Jonathan. Ralph, walk us through what that would mean. How could that even happen in today's political environment, and what that process would actually look like today?
Well, that's the key qualifier. There are not the votes, and there's not the political priority to do that. The means would be exactly what Roosevelt proposed in 1937. It would just be a new law that grows the court. And there is a fair basis to think that the ordinary process was manipulated, both in 2016 and 2020, after the death of Justice Scalia and President Obama not getting to fill that seat. And then after the death of Justice Ginsburg, President Trump very promptly getting to fill that seat. And those two being consequential appointments that distorted something that, naturally should have been the other way. President Biden, I think, very properly wants to spend no political capital on this anytime soon. He has created a commission that's filled with over 30 very brilliant, largely legal academics who have been talking and studying and writing. And there's a range of proposals ranging from statutes to constitutional amendments to retirement schemes and rotations that would try and depoliticize the court. I think that could be done without a constitutional amendment. In other words, a justice serves for good behavior under Article 3, which is interpreted to mean for life, but that doesn't necessarily mean a right to sit on Supreme Court cases until one expires. And so after a period of time, it could be structured that justices rotate into service on circuit courts or become a senior bench waiting in reserve in the event of a recusal or something. So these people would continue to be justices, but in the meantime, it would be a vacancy that would be created. And let's say every president in a 4-year term got 2 appointments, and that became a much more regular thing. That might take some of the political venom out of this process, but of course it would take a statute and then it might be challenged. It's ironic to think about how the Supreme Court would be asked to participate in deciding that. And after we got all past that, it would take some number of years before we were in the new regime of orderly and less politicized Supreme Court appointments.
Right.
So it's a very hard question.
Also, when Roosevelt came up with his court plan, it was immediately seized upon that one of the justices, I'm trying to think, not Cardozo, was it Brandeis who was 80? So he would have been knocked out, and he was very popular. So now, of course, people are living longer, so that age doesn't seem so old anymore. Secondly, look at the differences between Biden and FDR. I mean, Biden is much more careful, not as sure a political, sure-footed a political animal, although he's very good politically, as Roosevelt. And Biden didn't come off a 27 vote, landslide, 27 million vote landslide like FDR did in 36. They're very different people, and Roosevelt was very headstrong on this issue. Biden is not committed to this issue from what I can see. And yet the latest refusal of the court to delve into the Texas abortion law really, I think, flung a new element into the debate. For a long time, people were thinking, well, Biden's not going to invest his prestige on this issue. And now, yet, this, of all issues, is very volatile and caused a lot of, furor around the country. So I think that's a new element. That's interesting. A few more decisions like that by the court, and, it may move, this panel, this 32-member or whatever panel Biden appointed to come up with something.
Okay, we've got a couple of questions that have come in that aren't strictly relating to the court. I'll try to answer a couple of them. Princess Michelle asked again, who was President Franklin Roosevelt's friends with from the monarchy government of the United Kingdom? And of course, very famously, he invited the King and Queen of England to come to America in 1939. And Americans today don't fully realize that Americans back then didn't particularly like the British monarchy. Matter of fact, they had very low popularity ratings. The previous king had abdicated because he married an American. And so there was a real sense that the English monarchy wasn't really much to do. And Roosevelt knew that we had to solidify our relationship with Great Britain because the war was coming, and he knew the war was coming, and Britain was going to be a critical ally. So he invites the king and queen, and they have the big fancy dinners in Washington, and then they come up here to Hyde Park, and FDR famously has the hot dog picnic up at Top Cottage, in which he, serves hot dogs to the king and queen. They served other things too. I think you talked a little bit about that, Ralph, in your article on Top Cottage.
I think they try to serve some kind of a fruity cocktail to Winston Churchill, who spat it out. No, absolutely. That was a famous episode, and Roosevelt saw the need to cultivate, closer relations with England, which was embattled and at that point could very well have lost the war once and for all for the West. And he had this wonderful relationship with Churchill, of course, where they I think Roosevelt addressed him as I forgot what by a Navy title.
He was the former naval person.
Former naval person, right.
Okay. Originally, because he started the correspondence with Churchill when he was still the First Lord of the Admiralty before he became Prime Minister, in which case he would refer to him as the naval person. Because, of course, the President of the United States is not supposed to be talking to England's Navy Secretary. But then when he became Prime Minister, FDR always referred to him as former naval person.
Right. I spent the pandemic reading all 6 volumes of Churchill's World War II history. It was the only good thing that came out of the pandemic.
We have a couple other quick questions that we're running out of time here. So a question from Andrew Smith. I appreciate the important Supreme Court stuff, but I'm wondering if you plan to have another live conversation about other FDR subjects in the future. Well, first of all, we have been doing this for a year and a half. Every week or two, we do a new program, either the education specialist or the curator, or I do it. They're all available on our YouTube page and our Facebook videos. We've done everything from FDR's relationship with different presidents like Eisenhower and Johnson, to the Great Depression, to the Yalta Conference. There's lots of material there. Since we had to stop doing live public programs, we've done, I think we're up to about 75 of these conversations with authors and historians. So please, we have lots of content. We're going to continue to do this, and hopefully someday, as the pandemic eases, we'll go back to doing live programs, at which point we will continue to live stream them and record them and put them on our YouTube so that we have a collection of this content. Okay, this is going to be a last question, and it's a really good one. So it's from Joanne Moretz. Isn't the lifetime appointment supposed to be a way to avoid politicization and justices feeling beholden to a certain president or a political party's viewpoint? Lifetime appointment. Okay, Ralph, start with you. John, we're going to end with you. Give you the last word.
Well, that was the idea, and it refers to federal judges below the Supreme Court as well as the court, it's a wonderful mechanism for insulating them from the day-to-day political pressures. Used to be the FBI director had something similar, 10-year term that insulated him. I think that's it's worked well historically, and I think it'd be very difficult to take that away. I defer to John's expertise here.
No, I agree completely. It is valuable insulation. The question is, how much do you need? And lifetimes today can be very long things. So if there's a way to sort of permit a justice to serve out beyond the politics of his or her appointment moment, that is desirable and insulates them. But I don't think that needs to be 30, 40, or 50 years. I'll note, due to heart disease, Robert Jackson died at age 62 after serving only 14 years on the court. And one of those, he was AWOL, being a prosecutor at Nuremberg. So one can make his or her mark and do great service as a Supreme Court justice without needing many, many decades. And also, if we're not trying to play for forever, we might not prioritize appointing ever younger people, and perhaps we would get more of the career wisdom and experience of more senior people. 60 and 70-year-old people, including people who've held high public offices, are not viable Supreme Court candidates today. I think that's a terrible loss.
Right. All right, Ralph, John, thank you very much. Great conversation. And I think we all know that as U.S. Constitution Day, there are 3 branches of government. They just did a survey that said less than 30% of Americans could name all 3 branches of government. So here's your civic lesson for the day. There's the executive branch, which is the president. There's the legislative branch, which is Congress. And there's the judicial branch, which is the Supreme Court. They are supposed to be 3 equal branches, although none of them feel the others live up to their potential. On that note, I want to thank you guys. Thank you very much for coming. Thank you all for watching. And I hope that you'll join us for our next At Home with the Rose.